Welcome back. Duke University is being accused of unlawfully considering race in admissions. The Justice Department claims the university is using, quote, diversity essay questions to identify the preferred race for their admissions. Affirmative action in college admissions has been illegal since a 2023 Supreme Court ruling. The same ruling said colleges could continue to assess how applicants' backgrounds might speak to broader characteristics.
All right, joining us now, our chief legal analyst, Conley Frodes. Cleve, what Annie just said right there, how their background might apply. I mean, when you write these essays, right, if you're talking about how you've been brought up, your culture and all that, is that considered now inadmissible? Should that not be added? Break this down for us, what they've determined here with these essays.
Well, the 2023 case said that you couldn't use race as a determining factor.
Right.
But Justice Roberts, who wrote the opinion for the court, said that you may write an essay and describe your life experiences. And if race played a part in that, you may do that as well. And then when the institutions decide to give you credit for that essay, it can't be because of the race, but it has to be because of the experience. So even if your experience involves race.
Right.
A little bit of a circle, but it's saying that if I was before the 2023 ruling giving you credit because of your racial experience alone, that would have been something that's outlawed. But let me hit on a couple things and take us back historically. African American admissions to law school was something that was outlawed for a number of years. I mean, there was something called reading into the law. Do you understand what that meant? That meant you couldn't go to law school, so you had to go get an apprentice, that one or two black attorneys you found in the country, study under them, and then you would take the bar because you couldn't go to law school. And then after Reconstruction and the Civil War, African Americans started going into law schools. But it was much, much later that law schools in the South specifically started admitting African Americans. Brown v. Board of Education happened in the 50s. Duke didn't admit an individual that was African American until 1961. So we're talking about not a long time of African Americans being admitted into law schools. There was never in this country a quota system of admitting African American students. Prior to 2023's decision, what you could do was that you could have an intent to ensure that you had a diverse student base and use race as a decision-making factor. But you couldn't say, I want to ensure that I have 47 black students at my school. That's never been allowed in the history of the admissions of law schools, never could be. But what could be was the intent to ensure that you had a diverse base. 2023, the Supreme Court said, listen, if your intent to ensure that the base is diverse, that's something that you can't do. But the outcomes, if the outcomes are still there and they're still occurring, that's something that the court cannot describe, or I should say remove.
All right, so what do you see happening next here?
I see that the Supreme Court's words are going to be used against them, and this is going to be one that I hate to say it's going to backfire on the Trump administration's attempt to dismantle or remove race from academics. And I can tell you why. You have to look at the Voting Rights Act case that Justice Alito just penned. I want to say at the end of last year or earlier this year. In that opinion, Justice Alito said a couple of things. When they were talking about was the Voting Rights Act something that was allowed and required, Justice Alito said, well, you guys have not showed me one time intent. He said, you're showing me all these outcomes. And he said, that's great, but if you don't show me intent, none of that matters. Basically making the Voting Rights Act irrelevant, right? Fast forward to this case. Look at what the Department of Justice said. Black and Hispanic applicants admitted at higher rates. During the 2024-2025 admission cycle, the median LSAT scores of rejected white and Asian applicants were higher. What they don't say in any of this is intent.
How do you even go
so
about
all they're
proving
showing is
that,
outcomes.
Though? How would you even go about proving that?
Emails, letters.
You'd have to explicitly say, though.
Yeah, they'd have to be in a meeting.
Race, right?
They'd have to be in a meeting saying, we want to ensure that we have more African American students here, or we want to not moving from the quota portion. Even if they said this year we had 2%, we'd like to have 3% next year. That'd be a violation of the 2023 Supreme Court ruling. Finding some smoking gun like that is going to be near impossible. And again, I'll point to what the DOJ said. Not one of the things they mentioned was we found allegations of intent. All you found was allegations of outcomes. And guess what? The Supreme Court just said you can't use outcomes as a determining factor. So their own language that they've used to dismantle the Voting Rights Act will actually defend the very thing they're now trying to tear down.
Interesting. All right. So immediately, what happens next?
Duke will respond and they'll do their research and say, okay, you showed us these percentages and statistics, but now show us the intent. And unless there's some secret hidden meeting, unless there's some Zoom recording of them, writing these numbers down and looking for them to be increased. And let me put the percentages that we're talking about, right? In law school admissions, there's 7.6% African American first years, 7.8% overall African Americans. So we're not talking about some drastic shift of 90+% admissions. No, actually it declined after 2023. Some law schools this year admitted no African Americans at all. That's some of the things that have happened in the wake of the 2023 ruling. While the Department of Justice doesn't go after statistics, their goal is to ensure that you have compliance. So what's next is Duke will respond, but if they can't show intent, I think this one sits still.
Okay.
All right. Thank you again, our Chief Legal Analyst, Carly Frodes, weighing in on that for us.
Queen City News Plus. Just search Queen City News on your smart TV's app store.